Hi everyone, my name is Fateha and today I will be talking about state laws. Now, the government is usually run by a big central body of elected legislators known as the Parliament or Congress in the US. Within this Parliament, the controlling party with the most seats form the federal government. This federal government is in charge for all the big decisions in a country, be it social welfare, finances, or international relations, basically anything that you can think of.
However, some federal governments delegate a certain amount of power and autonomy to state governments to let them run day-to-day administration more easily. This is known as federalism, a two-tier system with a central government and state governments. Malaysia practices such governance with autonomy given to states for certain categories listed under List 2 of the 9th Schedule in our federal constitution. These categories include religious affairs, property, agriculture, forestry, local administration, state holidays, and even burial grounds. Sabah and Sarawak are given special control over their ports and harbours. This partial autonomy means that a great degree of laws differ from state to state. It also means that the federal government doesn't always get their way, and this can cause some friction. A recent example would be the tussle over several states that refused to follow new federal movement control order procedures during the COVID-19 pandemic. Many states, including Penang, Selangor, Sabah, and Sarawak, refused to implement more relaxed procedures during the fifth phase of MCO, citing that they thought it was too early and risky to loosen the rules. This led to proverbial jabs between state and federal governments through the media, including threats of legal actions against the states. Many legal experts have come out saying that while local state laws have some autonomy over how businesses are run, under the Local Government Act 1976, they cannot go against federal laws as stated under Article 75 and 81 of the Federal Constitution. Another example is the whole situation with the minimum age of marriage for Muslims. In 2018, news of a 41-year-old man from Gua Musang marrying an 11-year-old girl in Thailand sparked outrage across the nation. This was possible because while most state governments have a minimum marriage age of 16, Sharia court judges are given the discretion to allow younger girls to marry. This then led to a call of action by the federal government to amend the minimum age from 16 to 18 uniformly across all states. Since religious affairs are exclusively under the purview of states according to the Constitution, the federal government was powerless and was only able to lobby and persuade each state government to make the amendment on their own. Selangor became the first state to raise the minimum age to 18, but they didn't remove the power for judicial discretion for those who are underage, meaning that it is still possible for the Kelantan debacle to happen in Selangor. Penang and Sabah have also promised to amend their Sharia laws, but have yet to implement the proceedings. When it comes to federalism versus unitarianism, which is a strong federal government instead of a diluted one, the pros and cons vary. For one, federalism allows for unity without uniformity and encourages keeping the government closer to the people, in the sense that there are more arenas for public participation through the system. The most common argument for federalism is that it helps safeguard against tyranny. Those not in favour of small, localised governments would argue that conflicts may easily arise between state governments and the federal government, which potentially forms a hindrance towards national progress. Additionally, competing laws may serve as an even greater divisive force. The biggest downside of federalism in Malaysia is just how much power these states have over Sharia laws. While some states allow a great degree of freedom, with Sabah and Sarawak having the most lax laws for conversion out of Islam, some states use this autonomy to enforce draconian laws. In Kelantan, for instance, the religious authorities are empowered to fine and rebuke Muslim women who wear tight clothes or fail to cover their head. The federal government, however, does tuck in when it comes to punishments. Under the Sharia Court Criminal Jurisdiction Act 1965, all state Sharia courts are subjected to a limit of 3 years imprisonment, 5,000 ringgit fine, and 6 lashes of the cane for criminal offences, famously known as 356. In 2015, the Kelantan State Assembly had passed several amendments to their state Sharia law that included amputation as punishment under hudud. However, the state is unable to enforce these new punishments due to the 356 limitation.
All these shows that federalism, while imperfect, does still work. Both the federal and state governments act as a check and balance with each other to allow more efficiency, while localities have to make small changes based on their specific needs. While jurisdictional conflicts do occur from time to time, Our constitution is largely clear on what falls under the scope of state governments. So maybe the next time you have an issue with the rules and regulations, you may want to check whether you have to talk to your local assemblyman or your federal parliamentarian. Thank you for listening. Bye!